Chapter 11 process, it's you basically file the application and you have a lot of what we call first day motions. You got to file, and everything you do in a Chapter 11 has to be done with court authority. So even as simple as an application for employment of the attorney has to be approved. The attorney has to file an application, has to disclose any potential conflicts, has to disclose compensation and any other relationship that the debtor may have with the attorney, and the court has to approve that employment. If you're going to be hiring an accountant, if you're going to be hiring anything else, it has to be filed, and you got to ask the court for permission. If you're a business that's going into a Chapter 7, it depends on whether or not anyone has liens on your accounts receivable, because that's the main motion that you file, which is the first day motion, an application for authority to use cash collateral and make adequate protection payments. So you basically get through all the first day motions. Within 2 weeks, you have a informal conversation with the U.S. trustee, one of the analysts, what they call the debtor in possession conference, and that's going to be a preparation for what they call the 341 meeting of creditors, which is where the trustee will put you on the record, you disclose everything that's under oath, talk about all your assets, your liabilities, and you have to put yourself and make yourself available for any kind of questioning that any creditor may have. Creditors can show up, ask any questions about your assets, about the liabilities, about what the plan for the business is, what the restructuring efforts are going to look like, and that basically sets the tone for the remaining of the case. Depending on the case, whether it's a small business case or not, there's some deadlines as to when you need to file the plan of reorganization, but once you do that, you also file a disclosure statement that basically provides complete disclosure of the financial affairs of the business prior to the filing, during the the process itself, and what the goal is going to be long term once you disclose, who the insider is going to be, what kind of compensation, what terms you're going to be implementing long term. All that goes into the disclosure statement, and then once approved, that the court deems that enough disclosure has been provided for all the creditors to make an informed decision, then at that point you're given the opportunity to submit a plan of reorganization with all the creditors get to vote on that. There, you always want to look for a fully consensual plan. It rarely happens, but so long as you have one impaired class that approves your plan, then at that point you can do a cram down and basically get the plan approved. Once that happens, then you start operating on the plan that you propose to the court. Once the first set of payments goes out, then you move to close the case. That way you're not dealing with any more reporting requirements, because once you're in a bankruptcy case in a Chapter 11, then there's a lot of requirements you got to do, and you got to pay quarterly fees to the U.S. trustee. You got to file monthly operating reports, which basically shows assets, liabilities, income, anything that basically happened the month prior to it, and that gives the U.S. trustee, the court, and the creditors the opportunity to see whether your efforts to restructure are going somewhere, whether they're going to be successful, whether there's any likelihood of successful reorganization, or whether we're just delaying the inevitable. Once you do that, once you confirm the case, then you want to close the case so that you can avoid all those additional administrative expenses and requirements.